I would like to say that at Outright we are dedicated to the Yogyakarta Principles plus 10. Not only did we work on the original Yogyakarta Principles, but I'm really pleased to say that Outright served as a member of the Secretariat for the Yogyakarta Principles plus 10, which I will now refer to as the YP plus 10, just to save on a little bit of time, and also I will end up mispronouncing it as we go along. And we did that along with RFSL, Human Rights Watch, and the Williams Institute. So I'll be your moderator this evening, and this evening's event is actually a partnership. Outright Action International, ARC International, and Transgender Europe all partnered to put it together. And we are so lucky to have a wonderful gathering here up on the panel of community leaders who've led the process of developing the YP plus 10 principles, and in some cases have been part of the core drafting committee. And this evening they will present the document, answer questions, and engage in discussions on opportunities for cooperation. But before I go on to introduce our wonderful panelists, I just wanted to paint a little bit of a picture about why we're here and what we're here to talk about this evening. So as most of you who have been working CSW over the past week and a little bit, or maybe for those of you that have been working CSW for many, many years, I know there are a few people in here who are veterans of the space, we are talking about gender justice. And this year, we're talking about gender justice in rural areas. And so what does that mean? It means that women, girls, and gender non-conforming people and children continue to be economically and socially disadvantaged due to limited access to quality education, healthcare services, and other vital resources when they live in rural areas. And these factors, combined with others such as broad notions of patriarchy, and negative aspects of dominant economic models that work to erode the human rights of marginalized people living in rural areas. And we know at the UN that the Agenda for Sustainable Development and also General Assembly resolutions and UN Secretary General's report call on member states and UN entities to eliminate discrimination against women and girls and gender non-conforming people living in rural areas in a number of key areas, with particular attention to the most marginalized. And that's where we come in. LGBTI women and people living in rural areas are an acutely marginalized group. They're part of the picture of what we're talking about here at CSW. And what does this marginalization look like? LGBTI people continue to experience the same gender-based violence and discrimination. They experience extreme human rights violations because of their real, their actual, or their perceived sexual orientation, gender identity, expression, and or sex characteristics. And these violations include killing, torture, violent attacks, arbitrary detention, things like forced marriage, in addition to the denial of rights of assembly and expression, the non-consensual surgical intervention on infants and children, the forced sterilization of trans and gender non-conforming people, and then structural barriers in access to healthcare, education, employment, and housing. So today we want to explore some of these issues through the lens of the YP plus 10 principles. Many of you will remember the original Yogyakarta Principles, which were adopted in 2006. And we call them an authoritative interpretation of international human rights law. So that's existing international human rights law, not a new or special bracket of rights, but an analysis of the international human rights law that already exists. We created the principles a decade ago because, among other things, we didn't have a treaty on LGBTI human rights, and we wanted to amass a contemporary and international comparative law analysis in one place, to make clear the duties and obligations of states and UN mechanisms to protect LGBTIQ people from discrimination and violence based on their sexual orientation, gender identity, expression, and at the time, not yet sex characteristics. So the principles had a terrific impact globally because they functioned as a kind of a cheat sheet for advocates, UN officials, and governments to understand what best practices were in this area of human rights. Since then, we've seen significant advances in the rights of LGBTI people over the past decade. They include growing recognition around key principles such as gender expression, intersex rights, and the obligation to apply intersectionality to connect LGBTI human rights with core development principles like the right to sanitation and core transitional justice principles like the right to truth. So at its 10-year anniversary, we gathered to update the principles to ensure that they remain relevant and productive. And that's about where my expertise ends, which is really lucky because we have these 4 people who actually have a very deep level of expertise in this process and have really been part of it passionately for different periods of time, but have all contributed in their own ways to what is now really a fantastic new document that again looks at existing international law and how it applies to our communities and populations. So I want to introduce the panel. I'm going to just say their names, and I'd really love for them to tell you a little bit about themselves and what they're doing here. So we might start with Kim Vance on the end and move forward from that. If you've got a microphone, Kim. Old school, it's attached to a cord. So Kim, maybe you would like to introduce yourself, and then Monica, Keenan and Kimberly will go up that way, and then I have some exciting questions to ask you all before we move on to Q&A with the audience.
Great. Thanks, Siri. So my name is Kim Vance, and I'm the Executive Director of an international NGO called ARC International. We've been around since 2003. And one of the first sort of big pieces of work that we took on was the original Yogyakarta Principles in 2006, and we worked as sort of a team, a collaborative team of NGOs and experts that put that together. So 11 years ago, I sat in this very building when we launched those principles in a very packed room up on a different floor, much smaller than this. So it's great to be back 11 years later. Well, I mean, I've been back since then, but it's great to be back talking about the Yogyakarta Principles 11 years later, and to see such interest at 6:15 on a Monday night. Thank you very much for coming. So I'm going to give just a little bit of the history and the context of how we got here, and then the rest of the panelists are going to talk in a much deeper level about some of the content of the principles. But just to give you a bit of an overview. Thank you. So like Siri said, in 2006 the original YPs were launched, and they came about at the time sort of in coordination with the appointment of a new High Commissioner for Human Rights, Louise Arbour, who met with a bunch of NGOs in Geneva on the issue at the time of sexual orientation, and later gender identity came into the conversation, and said, you know, it's very hard for me to do some of the work that I want to do because the argument that I get from states all the time is that there's no clear legal principles that apply to these issues. Or if there is, it's kind of a patchwork quilt, and it's very hard to sort of say, you know, there's clear international law at play here, even though I know there is. And so we kind of, a number of us took that and ran with it and decided to be part of a convening of international experts who would actually look at where international law spoke to issues of sexual orientation and gender identity. That produced the original Yogyakarta Principles, and I want to just show 2 websites here that I'll refer to in my opening. One is the site that actually contains the true versions of the Yogyakarta Principles and the Yogyakarta Principles plus 10 in their official UN language translations, although I will say that the YP plus 10 have not been translated into all UN languages yet. It's coming. And then the second website is a website that we maintain called ypinaction.org, which tracks the use of the principles, how they're being used by governments, by NGOs, by in court cases. And it also has a number of other translations of the YPs that aren't sort of official UN languages, but have been translated in many, many different languages around the world. So those are the 2 websites that I would refer you to for these. There are some hard copies of the new principles available, but this is mostly now we're in the digital age and we did not print off massive amounts of these, so the websites are very important. So just a little bit about the process and the values that underlie both processes 11 years ago and now. As Siri mentioned, the original Yogyakarta Principles were about a coalescing of the current state of international law. It was not a visionary document. It was not meant to say, here's what we hope could be. It was meant to document what exactly already existed in international law that applied to concepts of sexual orientation and gender identity. And in that way, the YP+10 process remains true to those principles. Again, it is an encapsulation of international law as it exists today, 11 years later. And this is changing. I mean, even since this came out, there's been changes. So it was necessary to evolve the document, very necessary. Now, I will say that a lot of international law, even if it's agreed upon, is visionary. Many states are yet to achieve that far. So, you know, you could argue that it is a visionary document, but a lot of international law is visionary in that sense. But all of the principles have reference to actual decisions from treaties, comments, cases that have come before international bodies, reports of special rapporteurs. So in that sense, both processes were the same. The other way that both processes were the same is that they drew from a variety of expertise. So this is not a document that is just drafted by lawyers, even though it talks about international law. It's not a process that's just drafted by academics or NGOs. It's a process that's drafted by a group of people, all who have various expertise, coming together and analyzing international law and saying this is where these principles come from. The third way that both were the same is that there was a formal experts meeting convened in both cases. The first one in Yogyakarta, that's how it got its name, in a very UN type of way. It got named after the place where people met. The YP+10, the experts meeting happened in Geneva, but we didn't call it the Geneva Principles because Geneva already has so many principles, so they still remain Yogyakarta Principles, even though the second meeting was in Geneva. And there's also, for both of them, was a signatory process where experts could assign an endorsement. And that's different for both documents. And that's not to say that the original signatories don't endorse the second batch. It's that the second batch arise from a different level of expertise, and that's why you'll see different names. The fourth thing is that they're meant to be a document that has shared ownership. You know, obviously some groups here have been part of various levels of the process to create them, but they are not owned by any of us, and they are meant to be used, shared, widely distributed, interpreted, translated, whatever. And so in that sense, they're very much a community-owned document. And then the fifth thing that is common in both, which was quite groundbreaking, and I will say that as being part of the original process, we didn't actually know it was going to be quite as groundbreaking as it was, is that it goes into this tricky area of defining concepts. In the original principles, they were defining concepts of sexual orientation and gender identity, and within that, gender expression. And in the new iteration of the principles, there's new definitions around gender expression specifically, and also around sex characteristics. And these definitions have actually been quite important. They've been used in court cases and in decisions from courts, and have become quite sort of a defining, that's a pun, but anyway, a defining part of the principles. The areas where there has been some differences between the original crafting and this one is that a number of the experts in the room in Geneva agreed that what makes up the fabric of international law is understood or has evolved in 11 years. and is understood somewhat differently than it was 11 years ago. So we were able to actually pull from a much, I think, a deeper breadth of when we were looking for some of the application of these newer concepts. The second thing is that the experts, as I said before, are not necessarily the same in each of the processes, because the new principles are meant to both expand on and update the original principles, but also deal with some of the gap areas in the old principles that were not envisioned. I mean, the section, for instance, on technology, you can imagine 11 years ago was a whole different landscape. So the experts in the room were different and spoke to different sort of areas of expertise and spoke to some of the gaps. And in fact, I think only 2 of the attendees from the original experts meeting in Yogyakarta were actually present in Geneva. The third thing is that the process for creating the YP+10s was a much broader and transparent process. It involved an open call for submissions. There was, instead of one rapporteur like there was in the first process, there was a drafting committee, of which Monica was one of the members of that committee, who looked at all of the submissions, also added in their own expertise, and created a draft, which the experts worked from. And in that sense, it created a much broader community ownership, not just of the final document, but of the process leading into the creation of the final document. And that was a very important step, especially when you're trying to identify gaps. To have that kind of open and transparent process was very important. I think that's all I'm going to say, because I think probably people want to hear about the nuts and bolts of the actual principles and get into content.
Thanks, Kim. And you know, as someone that works in the UN space a lot, I have to say that like a document that is sort of crafted and based in community, which is speaking to the technical aspects of human rights, is such a welcome document, and the process of having it contextualized in the communities that it affects, for me, really speaks to the core of what human rights should be about. They are about individuals being able to understand and then realize their own human rights. And unless we're part of the process of, you know, creating an infrastructure around what that looks like, then it just becomes an abstract discussion in New York or Geneva. So for me, it was a really welcome process to kind of watch from afar. I realized we didn't actually get to continue down our line of introduction. So what I might do is just ask you 3 to introduce yourselves very quickly, and then I'm going to ask you a couple of questions about the nuts and bolts, as Kim has so eloquently put it. Monica.
Thank you. My name is Monica Tabengwa. I'm from Botswana. I'm the director of Pan-Africa ILGA, which is the regional network of ILGA, which we know and love. So my involvement really has been in the last 2 years. I have known and worked with the Yogyakarta Principles for many years, practicing law in my home country in Botswana. So they were not necessarily new to me, but being part of the drafting committee meant basically that in 2017, for about 5 months, we kind of lived and breathed these principles, which really was a good experience for me. I think for me and for Pan-Africa ILGA to be involved in this, there hasn't been a lot of involvement from civil society in Africa, and so it was very important that Pan-Africa ILGA as a continental network should be involved and should be part of this important development of a framework that has helped to move the development of LGBTIQ equality forward. So it's been a proud moment, a lot of work, and a lot of late night calls, because a lot of people were in different time zones, so it meant sometimes we met at 12 midnight. That's something that we have to deal with as we are a global network, and so that's important. So That's just the introduction. That's all you want for now?
Yeah.
I'm Keenan Russell. I am the UN officer at Transgender Europe. And I got involved with the Yogyakarta Principles in my previous capacity as the Human Rights and Advocacy Officer at the Asia Pacific Transgender Network. There's been a great deal of development in South Asia in the past 5 to 10 years legally around particularly gender identity and gender expression legislation, litigation, and adjudication. And so it was very important in this process, first, that my organization, previous organization, APTN, attempt to engage the update to bring some of those points of view into the discussion, and then I participated as a signatory in the final drafting of the document. Yeah, I'll just stop there.
Hi, I'm Kimberly Zieselman. I'm the Executive Director of Interact, Advocates for Intersex Youth. I live outside of Boston, and that's where we are headquartered. I have been involved in this process just for about a year. I was invited and very humbled to be part of the process in Geneva last fall, where we discussed the new principles and served as an expert, really from my own experience as an intersex person. And I'm now one of the signatories. And one of the most significant things, obviously, for me was the addition of sex characteristics being included in the principles, which is a really meaningful difference for intersex people and for the protection of intersex human rights, which I can talk about a little bit later.
Thank you. So I'm just reflecting on just the diversity that's sitting here, which is a small snapshot of the diversity of stakeholders and people that contributed to this process. And I'm thinking about my last week at CSW and about hearing a narrative from some of the participants in CSW about homogeneity, about there sort of being one concept of Africa, one concept of what an African woman is, one concept of what someone from South Asia looks like. And I'm hearing too this kind of like narrative about this imposition of Western ideals onto global South countries. And Monica, I wanted to start with you. Your experience as director of Pan-African ILGA and your involvement in the development of the YP+10 principles disrupts this narrative. Like, it disrupts the fact that there's one version of what Africa thinks about sexual orientation, gender identity, expression, and sex characteristics. And you and I had a little bit of a chat before we came in today about the concept of state obligation, about the role of states in relation to their citizens, and what that means under the umbrella of the YP+10 principles for LGBTI people. And I wonder if you can elaborate a little bit on what your thoughts were around state obligations in the YP+10 principles.
Thank you. So just for some of you with the text in front of you, that will be additional principle 30, which refers to the right to state protection. So if you can bring it up just for, yeah.
Slide 30, yep.
Okay, yeah, so this, basically like Kim was making the introduction, is we were not really creating anything new. We were basically expanding or elaborating on existing rights, and we know where those rights are, in UN treaties, in national constitutions, in many declarations that we have signed. There are rights there. But at the same time, like she said, time has passed. There are many different things that have changed. Technology has for sure changed. People's lives have changed. We are connected a lot more than we were 10 years ago or 20 years ago. And so how do we ensure that the interpretation of those rights that are in the treaties and in the national constitutions are interpreted in such a way that they protect everyone today and with the realities that we live in today, whether it's in Africa, Asia, or wherever you happen to be. So how do we elaborate those rights? And so we start with what we have, and we start with all the rights and the obligations that are already existing. And so we thought the best way to do is to start with this article, because it actually encapsulates everything, gives you the basis for all the others that follow. So it gives you basically what it is that is expected from a state. And so there are three things that basically you expect from every state. And because we already have the rights in the Constitution, and so there are three things, which is the right, the duty to protect, the duty to respect, the duty to protect, and the duty to ensure that rights are fulfilled. Now, the duty to respect, we're basically saying to states, it is not enough that you've written it down in a constitution. We know that in a lot of countries they have bills of rights, but at the same time, they themselves are involved in violation of rights. And so there's a duty to respect, which basically means that the state should not be itself be responsible for violating rights of people, especially LGBTQ women, right? And so this is very important for us. We felt that it was necessary to expand this. And how does the state ensure that it respects the rights that are encapsulated or that are contained in any constitution? There must be measures that ensure that people are able to access those rights. So for instance, if you take, I'll give an example in Botswana. 8 years ago, my organization, one of the organizations that I founded, we were denied the right to register. Register as an organization, which basically means the right to associate as lesbians, as gays, as bisexuals, as a group that has similar interests. And we were denied not because the right itself is not in the Constitution, but simply because someone decided it was against national security, it was against public interest, it was against public morality. And so effectively, the state was actually violating the right that it had put in the Constitution. So it was itself being responsible for those rights. Now, you can imagine that happening a lot, but there are a lot more. Living in a rural area, things become a little bit more remote because of access, right? We know already that majority of women in Africa, for instance, live in rural areas. And that means access to anything, whether it's health, access to reproductive health facilities, safe and free abortion, that becomes an issue. And states have an obligation to respect those rights. And so this is why we felt that it was important that we elaborate on this issue. The other thing that I said was the duty to protect. And here we are talking about rights being violated by others, not necessarily the state. The state has a responsibility to ensure that other people do not violate the rights generally, right? So once the right is there, the state has a responsibility to ensure that people do not violate this right. We're basically talking about ensuring that where rights are violated, people are prosecuted, due process of the law is followed, and they are punished accordingly. So we know what happens in many of our countries. I can pick a few where we know that people get beaten. South Africa, which is a country where I live and visit a lot, black lesbian women have been attacked, have been killed, and that's because the state is failing in its primary responsibility to protect. That means they don't even follow up on these laws to ensure that if that happens, people are investigated, those crimes are investigated, people are brought to the court and prosecuted and punished accordingly. And that's a violation of a right to life and many of the rights that are in the South African Constitution. So that is problematic, right? there's a lot of negligence as well, which basically means just ignoring the fact that such atrocities occur is a violation, right? So we know that societies, all our societies, many of our societies are intolerant. Our families are intolerant. But there are also laws that say certain things must not happen. And so the state has a responsibility to ensure that such laws are enforced. So just because you live in a rural area, you happen to be different, you identify as a lesbian or transgender person, or whatever identity you happen to have, doesn't mean that the state has no responsibility towards you. So this is what the duty to protect means. And then the other thing is around what I mentioned was the right that people should be able to fulfill the right. So here we are talking about everybody being able to access rights, to access facilities, to access health care equally, right? So again, examples are plenty, and you can think about anywhere in this continent where in wherever you live, where there has been denial of just going to the clinic and asking to test for HIV with your partner. And what do you get? I know in my country, if I take my partner today, there will be questions. There will be people looking at me as you. There will be, in the end, a lot of people walk out and they end up not doing those tests, right? And HIV in Africa, we all know it's a big issue. It's a big issue. People's lives have been lost. And there is need to access medication, to access those tests so you know what your status is. And so again, this is why Article Principle 30 is important. The other thing very specific about the theme, around poverty. We all know, we've seen studies, we've read studies, we've read articles. We know that if you're different, you're a young kid in school, you're likely to be bullied, and if you're bullied, the likelihood is you'll quit school or your grades will be so bad you won't pass anyway. What happens down the line? Your choices in life get limited. In the end, poverty is a problem. And so this would be referring to principle number 34. I think you can quickly bring it up. Okay. Thank you. So poverty is a big issue. It's a big issue for all of us. Why are we poor, and why do we continue to be poor? And we know what those challenges are and what brings about those challenges. The discriminatory practices that our countries, our government continue to practice, whether it's because of tradition, because of religion, or whatever excuse they come up with. It's a violation of rights, fundamental human rights, which we've all signed up to. We get this whole thing around religion being thrown back at us a lot, working in Africa. And it's around tradition, around... Yeah, so essentially what I'm saying is there is no justification. Rights, fundamental human rights are the most important thing for every human being. We are all born equal in dignity and rights. That's what the Universal Declaration of Human Rights says. And that's not just a song. No, it is important. We have what we call Ubuntu in Africa. And that's exactly, that phrase, that article encapsulates what Ubuntu means. It means respecting every individual, regardless of the difference they may have to you.
nobody is more equal than the other. And so this is basically what we were trying to come up with this. All of the articles, all the added, the additional principles to the original one.
Yeah. Thank you so much, and I hope you're okay. I've got water up here as well. You know, the thing that comes through so clearly for me is, and it is coming back to this concept of shared experience while having it CSW at the moment as well, is that intolerance, whether it comes in the guise of culture, position, or religion, absolutely cannot be used as an excuse for violence, and it cannot be used as an excuse for exclusion. And we are here to talk about being most marginalised in the context of CSW and New Gender 2030 living around the time. And I think this kind of concept of using existing state obligations to ensure that those responsible for their citizens are the ones that are held accountable in this. And you know, you need to write more articulately, you need to be a waiver at the end. You know, so a lot of this exclusion and this intolerance, it's coming from a place of, you know, it's based on identity and on people's identities and their expression and their sex characteristics, but also people's perception of other people's identities through their expressions. And, you know, I wanted to ask you a little bit about gender identity and expression, because it's really been a sort of, you know, set of definitions that have been picked up and expanded upon in the new YB term. And that's probably one of the areas we've seen the most progress in international human rights law, and also at a regional and national level as well in the last 10 years. Can you talk us through a little bit about what the role of gender identity and expression has been in the new YB term, and, you know, sort of perhaps also what your role has been in negotiating some of that space?
So the concept of gender identity and gender expression, it relates to all of us. We all have gender identity. We all have gender expression. We have concepts of ourselves as being not just a cultural idea of gender, not just the gender identity, something that's inside you and how you think of yourself. And gender expression is what we put on ourselves when we go out into the world, which may or may not clearly align with cultural accepted norms that men and women are, masculine and feminine, and also may or may not align with what the science of based on how a doctor perceives our body at birth. But all of this conversation goes to how gender is a cultural and interactive concept. Gender is a thing that exists based on the body of one individual, about how we interact with one another and how we interact with our bodies and our parents and other people. And because of that, because it's so important that the principles look at the way in which interactions between people are part of the expression of citizenship, and how our rights as individuals are protected in those interactions. So what I need to say is that because gender and gender identity and gender expression are all things that require you to put them on and then you to perceive them, any discrimination, violence, or stigma that I experience as a result is about something you perceive off of me in the same way that we perceive someone as a body that has a disability, or we perceive someone as being young or old, or we perceive the gender on a person, and we act on that perception. And that perception is the problem ultimately. Because we're perceiving in our minds about how they should be, and if it's different from what we perceive, then we react often in a negative way. That reaction, though, is not in line with the expectation of human rights, nor is it in line with the perception of individuals as a gender. So what the YB question does, in comparison with the original Yogyakarta Principles, is more actively separate the concept of identity and expression. And that's a really important move, because the perception that another person has and acts upon often is of people who are perceived as trans were recorded by an international project like the LGBTI data. And we don't know anything about how those people identify. They're gay. They can't speak to themselves. What we know is how they perceive. And in several cases in 2017 and many more since this recording started, we're talking about Cianan, who was murdered by a family member because of the way that they performed their gender, often much too young to have solidified an identity. But those children expressing themselves as honestly and as innocently as they can were built in victims of really affecting to the father, and their lives were lost. And so this is about focusing in on the state responsibility to protect everyone on the basis of their gender expression from be it physical violence or discrimination. The other piece that I think is really important to talk about in terms of the white people transgender identity and expression is how the concept of the right to legal recognition is elaborated from the original Yogyakarta Principles to the LGBTI. And set as markers on our identity documents are fundamentally rather archaic. When you go, for example, to the airport and they check your ID, they do not then check your chromosomes or your genitals or your secondary sex characteristics. We clearly, as society, suspect that that would be a violation of your right to privacy and of your body integrity. PSA doesn't get to take your blood and collect your chromosomes to figure out your sex. But we use that as a marker of someone's identity, and that marker is based only, again, on the perception of an individual. When you're pulled over by the police, they don't have the right to take your blood and to test your chromosomes. What they do is look at you and act on their perception. And so the white T+10 say that to fully protect the rights of people on the basis of gender expression, we need to obliterate gender markers and sex markers on identity documents, because they serve no purpose other than to exacerbate our individual biases on the basis of perception. And I think that's a really important move forward in this discussion, because we're hanging on to something that no government, literally no government in the world, uses as a mechanism to verify your identity. We use iris scans, we use your picture, but no one tests your blood to determine if your driver's license is the person that you are. And certainly we don't test your chromosomes. That costs us $1,800.
Thank you so much. You know, one of the things that struck me as you were talking was the high price that gender non-conforming and trans people pay for their difference. When you talk about the number of recorded murders, not even the number of actual murders, that seems to me like a totally unacceptable number. I mean, one is an unacceptable number. And you spoke specifically about the risk that young gender non-conforming children have in their own families. And that, for me, casts a different light on the debate we have here about families. Families as the fundamental unit of society can also be, for some, especially in our communities, the place of highest risk, the place where we are, you know, young children are actually subjected to violence and even murder because of perceptions of who they are and ideas about what's acceptable and what's not. So I'm so glad to hear that the YP+10 had such a rigorous discussion about these concepts. I also loved what you said about the TSA trying to figure out your sex. You can imagine they usually go through my suitcase, which meant that I have to have a TSA compliant lock. I was just imagining what it would be like for all of us to have to then also go through another process of having our sex figured out. And I was thinking about the assumption in that sort of like exploration that there is like two sexes defined, male or female. But you know what we know now, and you know who we have here to talk about that is Kimberly, about this kind of diversity of sex characteristics, that our ideas of what constitutes male and what constitutes female, in the same way that technology has progressed, we've actually also progressed in our knowledge about what that means. And I've certainly had the privilege of learning more about that in the last decade. So
Kimberly, you're here to talk about sex characteristics. Perhaps you could start off explaining a little bit about, what that means for you, and then also what that's meant for your involvement in the YP+10 and the way in which that's sort of translated into the final document.
Thank you. Yeah, so if TSA was to look at my passport or my driver's license and also do a blood test, they would be confused because it says female as my gender marker, but my chromosomes are XY, which are typically known as male. So I was born with XY chromosomes and internal testes, and no internal female reproductive organs. Those are all examples of sex characteristics. And I'm an intersex person. I identify as an intersex woman. And just to be clear, the definition of intersex is somebody who is born with one or more physical sex characteristics that don't line up with what medicine and society typically thinks of as either male or female body. And we're not really as rare as you might think. We've often been very invisible. I like to say the I in the LGBTI doesn't stand for invisible. It stands for intersex. But we really have been invisible largely due to the shame and stigma that society has put on intersex bodies. But nearly 2% of the population is born with one or more intersex traits, and that's about the same as people born with green eyes, in which case I won the lottery, I got both, or red hair. So if you have green eyes, red hair, and are intersex, you're trifecta. And the reason this is a human rights issue, just to cut to the core of the issue, and the reason that I do this work, and my organization Interact exists, is to stop the human rights violations that are happening on intersex people, particularly young people, infants, children that don't have a voice, people at an age where they cannot consent to medical procedures that are done to them. And this is our core issue. Unique and a bit different than sexual orientation or an identity expression. Sex characteristics are something that they are what they are, and sometimes intersex people are born with sex characteristics that are visible and obvious at birth, and sometimes they're not, such as in my case, it wasn't discovered until I didn't go through what a typical female puberty would be. So it's really an issue of medicine and society trying to fix what they consider bodies that need fixing to fit into binary boxes of either male or female. So there's a lot of overlap and connection between the oppression and the stigma and the human rights violations that are happening to intersex people, that are happening to trans people and gay people and lesbians. And I think it's really important that we're included in this discussion. And one of the most exciting things to me about this process was the new inclusion of sex characteristics as a basis for discrimination. So I was just going to point out a couple of specific principles, starting with number 32. Number 32 is the right to bodily and mental integrity. And it talks about everyone having the right to be free from torture and cruel, inhuman, and degrading treatment or punishment on the basis of SOGIESC. And it specifically says no one shall be subjected to invasive or irreversible medical procedures that modify sex characteristics without their free, prior, and informed consent. So that's huge. And specifically the state obligations, we further clarified that this will guarantee and protect the rights of everyone, including children. And that was a very deliberate decision and discussion to include children in this, because children are not given the opportunity. And so this is really, really important. The other principle that I wanted to highlight was, let me see, go back to my empty document here. It's the right to truth, so it's principle 37. And this is really kind of unique, and I was so glad that this was included. It basically gives every victim of human rights violations a right to the truth of their situation, and specifically when we're talking about intersex people and the violation of invasive, irreversible, unwanted, medically unnecessary procedures on their body, whether it be reducing the size of the clitoris, removing a penis, removing internal testes or ovaries. They all are, the principle here is recognizing that despite these human rights violations happened, the victims have a right to knowledge and about truth about what happened to them. And this is really significant for intersex people. I mean, I know hundreds and hundreds of intersex people, and we all share very similar stories of not knowing the truth about our bodies and what really happened to us as children. And we all have varied stories, of course. My own is not finding out the truth until I was 41, which was 10 years ago. So I went from age 16 when my surgery happened, and I was told a bunch of lies about what it was. This was pre-internet, to 41 before I found out the truth. And so the last decade has been a real journey for me in fighting for intersex rights and for children to have a voice and to have a truth and to know their truth. So this principle is very, very meaningful to me personally. I think that's about what I wanted to say.
Thanks, Kimberly. And it really does shed a new perspective on this concept that we often throw around at the UN about harmful practices. And we've always talked about this in the context of maybe female genital mutilation in an African context. And the truth is actually harmful practices are happening every day on the bodies of infants that don't look that different in this city, that can really do similar things to the victims of female genital mutilation in some circumstances. And yet we don't have a language around that yet that's kind of socially acceptable, because it means that, sort of global north countries also have to consider what it might mean to have a harmful cultural practice, a medically unnecessary harmful. Thank you all so much, and I do want to leave some time as well for Q&A for the audience. I know for me, I've been really wanting an opportunity and a space for me to get a bit more deeply into these principles. I've been so excited about their release, and their application and their implementation really interests me. And before we do hand it over to the floor, I wanted to ask you all to kind of reflect on one thing that you would like people to take out of these principles, like one application of these principles that you feel would be, the take-home message that you would like people in this room, or perhaps people to share from this room with them this evening. And I'm going to go back in the opposite direction just to kind of share the love a bit. So Kimberly, tell me what do you think, what's the one thing you'd like people to leave with in terms of these principles?
Sort of in terms of these principles, I guess for me it's a little bit easier because I suspect many of you didn't really know what intersex was when you walked in this room. And I suspect many of you didn't realize you've met an intersex person before, now you have. So intersex is still such a kind of new concept for a lot of people that I think the one thing I want you to go away with is an general understanding of what intersex is and who intersex people are, and the importance of including them in these discussions.
I like the chord. I think the thing that makes me as excited as I am about the Yogyakarta Principles and the YP+10 is that their foundation is existing international law. And these conversations of interpretation are existing interpretations. And I find that to be particularly profound when thinking about the human rights that should be afforded to all of us, including on the basis of sexual orientation, gender identity, gender expression, and sex characteristics. Because what we're talking about are components of the Universal Declaration of Human Rights, things that have been around since the founding of the United Nations, and how those things have been violated on these particular axes. This isn't a new discussion. It's in fact a quite old discussion. And what we're doing specifically is clarifying the points where that discussion is still falling short. And that's a particularly valuable angle for me when talking about the YPs.
I think my addition to this would be just basically what I've said before is we are not creating anything new. We have had rights in treaties, in our constitution. But what we know is all of these are living documents. They are organic. They grow with us. They grow with society. As much as tradition is itself a dynamic concept. And so when people are always claiming that this is against African tradition, African values, and you ask them, what the hell is that? I mean, how do you even begin to define what African tradition is? There are more than 50 countries in Africa, all speaking different languages, dressing differently. We look as different as 50 countries can look. And we have different traditions, we have similarities. So when you say, when a government says this is against African traditions, and I often ask them, what the hell are you talking about? They are human beings, that's one thing. We are all human beings, and we deserve to be respected. We deserve to have our dignity, our lives be respected. That's all that counts. So we are not creating anything new. We are basically reminding you of your responsibility, which is respect every human being.
I guess for me, the one takeaway is, especially as we're convening in the CSW space, which has been a very problematic space for many of us for many years, it's actually one of the least progressive UN spaces on these issues. It should be one of the most progressive spaces. And I guess the takeaway that I'd like to sort of give people is that this would be alternative to the CSW. So where we cannot get agreed language with states who are all over there negotiating in these backroom deals and find these issues very contentious, too bad. It's already an international law. And in fact, you've already agreed that, by the mere endorsement of the Universal Declaration of Human Rights and by treaties on torture and all kinds of other things, even if you think it's contentious over there, you can't do it. And so this is kind of the alternative to what's happening over there when we are sort of grinding our fingers off, trying to get the most minuscule little advancement on language. This is the your beacon of hope.
What a phrase to end on. Your beacon of hope. And Monica, also this concept of you're fighting for dignity and we're fighting for our lives, and this document is a reminder of your responsibility in that. It's not a new set of rights. So look, we've got about 20 minutes or so, and you really have been sitting here so attentively listening as I have to this wonderful panel, and I wanted to open it up to the floor to offer you the chance to engage with these experts. It's a unique opportunity. CSW can be frustrating, but it is also an opportunity for many of us to convene in the same physical space where we're often